Our next speaker is a distinguished legal expert with over 2 decades of experience in litigation, regulatory law, and real estate matters. He is here to speak on legal remedies and dispute resolution in redevelopment. Practicing since the year 2000, he has appeared before the Supreme Court of India, Bombay High Court, Maharera, the Appellate Tribunal, and several other judicial forums. He also played an important role during the implementation of the Real Estate Regulation Act 2016, contributing to the formulation of the Maharashtra RERA rules. Widely respected for his legal expertise and industry knowledge, he continues to advise several government bodies, institutions, and organizations. Ladies and gentlemen, please put your hands together in welcoming on stage Advocate Harshad Bhadbhade-ji. Please, a big round of applause for Harshad ji. Bahut shukriya, sir. Thank you so much for joining us. Grateful to you. And the next few minutes is all yours. Thank you.
Thank you very much. Good afternoon, everyone. This is not working.
One request before you start, sir. We have been observing a lot of mobile phones ringing in the room, so we'll give you 10 seconds to please put your mobile phones in silent mode. वरना हम फाइन भी लगा सकते हैं यहाँ पे, वो भी बोला गया है मुझे. So we'll request everybody to please keep their mobile phones in silent mode if it is not already on silent mode, because we don't want to distract the speakers who are speaking over here. So can I have a thumbs up maybe from everybody? Is your phone in silent mode? Can I have a thumbs up, everyone? तो अभी जिन्होंने thumbs up किया, किसी का अगर phone बजा तो फिर direct smart will impose a fine. Just kidding, no imposing of fine. Just want to be kind to the guests. Thank you, sir, and over to you.
Good afternoon, everyone. So I think you are having good time and very knowledgeable lecturers before me. So pardon me if I commit some mistakes while updating you about the legal remedies. So it's a very interesting topic for the simple reason when Mr. Shah told me that you have to speak on this in a program which is called upgrading and mainly of construction. So we will look at it from 2 angles. One is redevelopment of the societies and one is the litigation from the angle of builders. So Mr. D'Souza, I am told, have already informed you about the redevelopment process and how section 79A is to be followed in brief. Now I'll tell you what happens when something is not going the way it should. So let us start from where Mr. D'Souza told you about section 79A. Let's take a society which is now following 79A. Now in 79A there are 3 top builders competing. Their offers are very good. One set of society members like one presentation of a builder, offer of a builder. Another set of society members like another offer of another builder. So the first round of litigation begins regarding appointment of promoter. Now what happens and where one should go, or rather the members of the society can redress their grievances. So as you are aware that cooperative societies are governed by Maharashtra Cooperative Societies Act, and any disputes or decisions taken in special general body meeting for 79A or any disputes inter se members regarding the decisions taken by the general body meeting or by the committee members will have to be taken to the cooperative code under section 91 of the Maharashtra Cooperative Societies Act. Now this is one set of dispute where the members are fighting, or rather at litigation, on the point of appointment of promoter, on the point of terms and conditions of the development agreement, on the point of facilities which are to be provided, and on the point of agreements or decisions taken in the general body meeting. The second dispute, which is at the initial stage of redevelopment, is the deemed conveyance. Now what is deemed conveyance everybody knows, but just to quickly tell all of you, Once the society receives occupation certificate, the then Maharashtra Ownership of Flats Act mandated that within 90 days, the conveyance of the building is to be executed in favor of the society, thus transferring the common areas and the building to the society. In recent years, it was observed that for various reasons, this was not being done, and therefore there was amendment to MOFA, and this concept of deemed conveyance is introduced. So what is deemed conveyance? Deemed conveyance is where for some reasons the developer has failed to or neglected to execute conveyance in favor of the society. Then the society can approach the office of registrar. They will have to submit the necessary documents such as occupation certificate, the registration certificate of the society, various sale deeds executed with its members, agreement for sales executed with its members, including index 2 of their respective apartments, and apply for deemed conveyance. Once that deemed conveyance is granted, the society becomes the owner of the plot, and that's how the first stepping stone for redevelopment begins. That now the society is owner of the plot. As has been explained to you, 79A will trigger, they will have their meeting, and as I mentioned, if there is any dispute between the members of the society, then they will go to the cooperative court and sort their remedies available. Now, the next stage of litigation. The next stage of litigation is between the members of the society and the builder, which you can see here. Now, the first complaints which we come across during the process of redevelopment is non-receipt of the rentals. Now, the remedy available to the members of the society, depending upon, of course, the development agreement, if there is an arbitration clause provided or if there is any other remedy provided. Otherwise, you can file a suit for recovery of your arrears. Same is the case with your corpus and your other facilities which are to be provided. Another set of litigation which you will come across during the process of redevelopment is what if there is a delay in completion of the building. Now we have to look at it from two angles. One, which is explained to you by Mr. D'Souza, that is for the flat purchasers, the remedies in RERA, where under section 18 they can file complaint for delayed possession and seek interest, or at the same time they can seek to exit from the project by taking the money along with the interest accrued thereon. They can also sue for compensation. As far as the members of the society are concerned, now they have different remedies. A, they can opt to terminate this developer. Now this is where the Pandora's box open according to me, and the whole lot of litigation in Mumbai is going on. So when society decides to terminate the developer, we have to look at it from three angles. That is, there are three participants in any project. One is the society, one is the developer, and one is the new flat purchasers. So when a society decides to terminate the developer, developer may have a clause of arbitration in the development agreement. He may choose to invoke arbitration. What society has is similar. The society can choose to invoke arbitration or move the civil court seeking termination of the developer. Now interestingly, what the purchasers have, whose stake is also involved. Unfortunately, the law says that they have to prosecute the erstwhile developer. Though personally I do not agree with this law, or I may have some reasons to that, I keep arguing whenever I get an opportunity, but the fact remains the law is, which is starting from Vaidehi Akash to Goregaon Pearl, the law which has been laid down by Bombay High Court is that in case society terminates the developer and that there is no specific performance granted in favor of the developer, then the flat purchasers will have only option of claiming damages and money from the erstwhile developer. As far as the society members are concerned, as I informed you, that they can go to the arbitration depending on the agreement or to the civil court, and then after terminating the new developer, they can again start the process of appointing the new developer in place of the existing developer who has failed to complete the project. Now, another question which we have to consider is that in case of termination of developer, what happens to the existing plans which are sanctioned? What happens to the existing various facilities which are already possibly used or implemented by the developer? Now, as I said, of course it depends mostly on the agreement, but mainly the developer can claim damages from the society for the monies invested by the developer, but the society can continue the project from where it is left by the promoter. So in nutshell, I always had a question in my mind as a litigant, as a lawyer representing various builders, that if I have constructed a structure, half, whatever, part, and I have paid various BMC taxes, BMC charges, now I have taken that money from the flat purchasers, paid it for the development of the society building, and now the society has terminated me, the money belonged to the flat purchasers, they are going to sue me. Now what is the option for the developer in such scenario? Where does he go? And as I mentioned, the only remedy he has is to file suit for damages and or for recovery of monies which he has invested in the project. Now, there is another set of litigation. This is extreme, where the developer has failed. Another set of litigation is where Milind was here explaining to you various benefits of amalgamation of plots and cluster development. Now, what happens that when a developer came to me, he executed one agreement of my individual building. But then subsequently he got another plot adjoining to my building, another plot adjoining to my building, and then he amalgamated this and there is a deviation of the plan. Now, interestingly, it happens that a person who had a sea view, and Mr. Changani is here, he will also answer this question whenever anybody asks. But a person who has a sea view, a person who has a garden view, all of a sudden gets something else, his floor is shifted, his PAAA which is already executed is affected because of amalgamation of plot and the change of plans. Now, what is the remedy to the society member? The remedy to the society member, first of all, I must tell you, that is why I took Mr. Changani's name, because yesterday only I had an argument in court. Interestingly, BMC mandates that you must get NOC or consent of the society for change of layout. And again, Mr. D'Souza is also here, he would say that RERA says you have to take consent of the flat purchasers. Now, please see the situation here. So, here is a builder who amalgamates a plot. Now, BMC says get consent of the society. Now, that consent, even if you have, is of no use, because RERA will say we will not permit you to change the plans because you don't have consent of the flat purchasers. Get that consent. So now again there are two sets of litigations. One between the society who says, how did you change the plan without my consent? Again the same set, whether there was a special general body meeting called for taking such consent or individual consents were obtained. Because interestingly, I must tell you, because here I am told that also discuss some case laws. So society, once it is formed, individuals have no separate identity. You are claiming through society only. So the correct way, according to me, of taking consent of the society is obviously by a resolution of the society, and not taking consent of individual members and then claiming that I have 2/3 majority of the members of the society. That may not be of any help. What you need is the consent of the society passed by a resolution. So this is the second set of litigation when there is a change of plan. There is section 14(2) of RERA, where the flat purchaser can file a case against promoter that, look, I had a sea view apartment, I had a garden view apartment, and now you have changed it without my consent. As a matter of fact, section 14(2) is very clear. There cannot be any change in layout as well as building plan, even his apartment plan. So even if you are giving additional FSI or you are getting additional FSI, because of which you are giving extra benefits to the flat purchaser, still you have to take his consent and upload your changed layouts on the website after the consent is obtained under section 14(2) of RERA, and you have to apply to BMC after taking consent of the society. Now I always say that if you consult one person as an expert, he can be anybody. He can be a lawyer, he can be an architect, he can be a project management consultant. But when all of these come together, and you disagree with one of or few of them, then there are charges first of something extraneous material involved in it. So when two society members are at loggerhead, obviously the one with minority will say that there are some benefits passed on to the members of the committee members of the society, or some interest passed on to the society, and there will be a litigation in respect of that, which again goes to section 91, under section 91 to the Cooperative Societies Act. Now this I just explained RERA and changes in this. Now we have considered the dispute midway, where the developer decides to change the plan, what happens and what are the remedies. Now we will see when the projects get complete or the developers brings the project to completion, what are the possible litigations which may happen or come across. So as I one mentioned, if there is a delay in handing over possession or change of layout or anything, then there is a litigation. The second important aspect is, once the building receives the occupation certificate, handover of the building and common areas to the society. So now here is a stage that the society handed over a particular building for redevelopment. It went through, the developer completed the project, obtained occupation certificate to the building, and there are certain defects in the building. So if there are certain structural defects in the building, RERA mandates 5 years from the last sale. 5 years from the last sale, the structural defects are to be looked after by the promoter. And if there are any defects, then those defects, the complaint can be filed with the authority for curing the defects. And also the society. What happens to the society? Now this is a society which will take charge of the building, but while taking the charge of the building, now there are flat purchasers also who become members of the society, who are added as members of the existing society. Now in this process, one of the known disputes are car parking. it's been years that the question has been asked whether developer can sell car parking or not, whether developer has right to allot the car parking in the common areas. The answer is simple. All the common areas belong to the society and therefore parking belongs to the society. Now after introduction of RERA, those which are closed car parkings that can be sold by the developer. Now the question always comes is how do you interpret closed car parkings? Whether a mechanical car parking is a closed car parking, whether a car parking in the stilt area or in the covered area is a car parking. The answer is simple. You need not go to any lawyer for that. It is in your sanctioned plan. Whatever covered car parkings your architects have said these are covered car parkings, are covered car parkings. Whatever are open car parkings are open car parkings. By putting some cover or by putting walls from three sides, you don't call it a covered car parking. It has to have a sanctioned plan to that effect. Now, having come to the litigation of car parking, the second is always about the collection of various charges which the promoter takes from the flat purchaser. So what happens to that money? So the law mandates that whenever promoter hands over the building to the society along with the common area, he is required to give the accounts also. About an interesting case I will discuss. I am told there are some builders and big projects which were discussed by Mr. Changani also. So a case which I recently argued is where a builder collected membership charges for a clubhouse and maybe about 2,000 flats into a substantial amount of clubhouse charges. While handing over it to the society said, this is a common area, the clubhouse is belonging to the society, so the amounts which are collected by the builder as and by way of membership of the clubhouse, running into few hundred crores, must come to the society. So I am not commenting on it, but the point is that how the litigations, we are here to discuss what are the possibilities of litigations and remedies. I am just pointing out that whenever in an agreement you specifically mention and collect monies for other heads, remember that you are inviting something after the occupation certificate is received. Now, another set of litigation, as I said, maintenance charges, same comes with the collection of land under construction tax and what happens to that, whether the society is required to pay land under construction tax or at the time of handing over possession of the building, the land under construction tax is to be paid by the developer and then you have to get a clean property. So I always say you take care of it in the agreement that till handing over of the building to the developer, the taxes are all taken care of, and while taking possession from the developer, the taxes are all taken care of. So it is a duty of the promoter to pay all the taxes, of obviously land under construction and other taxes, and while handing it over to the society, he has to give all these documentary evidences, because I have come across litigation where the corporations have issued notices after 2, 3, 4 years at their will and convenience, calling for those taxes, and because those taxes are not paid, they are charging higher water taxes or higher other taxes, and the societies are suffering. So we have to look after these issues also. Now we are coming to the state where the society has taken possession of the building. What happens if it is a layout? Now many times you come across an agreement executed with individual flat purchaser where it is stated that the formation of the society and conveyance of the plot will be done when last building is developed. Now this is very interesting because the law provides that the conveyance of the plot is to be executed as per the provisions. Now once the OC is received, within 3 months you have to execute the agreement for sale. Now the interpretation is or otherwise provided. Now where is this or otherwise provided? In your agreement. So or otherwise provided takes you and your conveyance to the last. So there have been instances where a question was framed whether part conveyance can be executed. That is, whether the project which is completed, to that extent conveyance can be executed by protecting the builder about his rights of developing the balance plot potential or by utilizing the balance FSI available. And the answer has been positive that yes, you can execute the conveyance in parts and protect the developer's rights of development in the balance plot. Now very interesting question comes, and the litigation. The litigation relates to that when we purchased the apartment, obviously the brochure contained that there are about 20 facilities which will be provided along with the project. Maybe swimming pool, maybe gym, maybe other services. And when we actually went to the promoter to ask for those services, the promoter said it will come with the last building. Now what is a remedy? So section 12 of RERA says that whatever you have promised in the brochure or in your advertisements materials, you have to deliver. And if you do not deliver, then the buyer can approach obviously RERA and the society members can file a suit again for specific performance of the facilities which are to be provided and for damages. Another set of litigation which I came across is what happens. Let's take a case where there are 5 buildings constructed by the developer. In one building there is a gymnasium, in another building there is a swimming pool, in third building there is maybe a wash court, in fourth building some other some other facility provided. Now for some genuine reasons possibly, one building which has a particular amenity denies access to others, saying that it disturbs our privacy, or your cars come for swimming pool, or you come by many cars, whatever reasons, genuine reasons maybe, but still they refuse to give access to the other building members. Now very interesting situation arises is because the builder says I have delivered the facilities and amenities, but the flat purchaser says that you might have delivered but I am not able to enjoy them. And it is for the builder to provide those facilities and you have to step in and solve this issue. What is the remedy? You already, as I gave you an example, that society is formed, the plots are handed over. Now there are multiple remedies, but one such remedy is one building who is restricting the access. You can, the other members of the society can pass a general body resolution or special general body meeting can be called for not or for restricting them from behaving illegally. Builder can file a civil suit for not obstructing the access to other members of the society members. And obviously the other society members inter se file a dispute under section 91 saying that these are common areas of the society and we want to enjoy these areas of the society. Now, one of these cases which are always discussed is, of course we are lucky, I would say, that promoters from Bombay may not have faced it. When I was in Haryana, when RERA was coming, we came across a situation that there is one building constructed, there is another building constructed. In between those two buildings is Yamuna Highway. So there is absolutely no access from one building to other building, forming part of the same project. You have to travel maybe 30 kilometers and take a U-turn just to use your swimming pool or something like that. Now, same thing happened when our expressway initially was planned. If all of you may be aware of those projects in Pune. So what happens? So there is a law. Now RERA says, interestingly, only force majeure. Now what is force majeure? It is mentioned. Act of God. This is not act of God, this is act of Babus. They forgot to take a turn, the road went straight. Now what happens? So there is a rule 6 provided. Now I must tell all the promoter here that there is a provision in rule 6 of RERA where the promoter can approach the authority. See, there is a Supreme Court judgment called Newtek which says that irrespective of any defaults, any reasons, if you cannot attribute a reason to the flat purchaser for delay in your project, the developer must pay compensation. That is what Supreme Court says. Now Rule 6 of RERA provides that where there is a genuine situation like litigation or change of law or government policy has changed, because of which there is a delay. I'll give you two quick examples when I say government policies or anything. So there was appendix to the development control regulations on granting certain FSI benefits. In one of the projects it happened so that based on that appendix the project was sanctioned, approved, halfway sold. Then one of the municipal authority realized that this appendix by an amendment was deleted. So we have wrongly given benefits to the developer of FSI which we should not have given. Resultantly, the project which was running into 32 floors straight away came down to 16 floors. Similar thing happened in our Parla area where the aerial distance was restricted or because of aviation policy, the buildings had to come down. In such situations, Rule 6 provides that builder can approach the authority and can inform the authority, plead the authority, of course by making all the parties concerned party respondent, that the delay or the reason for non-completion is beyond my control and mainly because of the policy changes or the rules and regulation changes which are there, and therefore can those particular period which is required for completion of the project can be exempted or excluded. So those who are aware of this concept of extension where there is a delay under section 7, you have to apply to the authority for extension of the project. Now what rule 6 says is exclusion of the period for completion of the project. So this is a distinction between extension and exclusion. One is simpliciter granting extension to complete the project where the liabilities of the developer under section 18 stands and he has to service interest, compensation, etc. But where the period is excluded, like COVID-19. When COVID-19 came, you might have come across two circulars. The first circular of RERA specifically said that compensation is not required to be paid. The second did not do so. Second said we are granting you extension, but you are required to pay compensation. So that is how the, I'm sorry, my discussion is not going as per this. I think I have almost covered, rather I have covered something more than that, so we can just overlook this. So now the last, as I said, I was on the point of section 7, extension and exclusion. What is extension? As I said, if the developer has consent of the flat purchasers, 2/3 majority, then he can straight away go to the RERA authority, say grant me extension to complete the project by a period which is required by the developer. If he doesn't have a consent, then he has to make an application to the authority, and after hearing the developer, the authority will consider granting him extension, which is section 7. Now section 8 litigation, which is very interesting part, which is still developing law. Now what is section 7 and 8? What happens where developer abandons the project for the reasons maybe A, beyond his control, or B, that he cannot complete the project. Now what happens to that? We must note that at some point of time there were more than 2000 abandoned projects in Mumbai itself, the MMR region. So what happens then? A procedure was formulated by the authority that under section 7, the society or the association of allottees can make an application to the authority for takeover of the project and say that they will take the project from here onwards and complete the project. Of course, when you make such an application, the association of allottees have to give the steps they will take to complete the project, the process they will follow for completion of the project, and depending on the proposal submitted by the association of allottees, the project can be handed over to the association of allottees. Now here interesting question comes, is whether unsold inventory of that developer can be sold by association of allottees to complete the project. The answer is no. The answer is no, you cannot sell, because that is totally a different right altogether under Transfer of Properties Act. Of course, if the authority passes an order or there is a government resolution to that effect, it's a different story. But directly, just because you have taken over the project, you cannot step into the shoes of the promoter and start selling the unsold inventory. That is one of the set of litigations which we come across. The second stage, as I explained under section 7, is once the project is abandoned and association of allottees is also not ready to take over the project. Now what? Under section 7 and 8, then the authority shall take steps to take the project to logical end for completion of the project in consultation with the government. Various steps the authority can take to complete the project. Now, the last situation is where the project is complete and we go to the stage 1. Still, the builder now is not executing conveyance in favor of the newly formed society. Now, in view of RERA, you can again move the authority under section 31, say that as per the law, it is mandated to execute the conveyance within 3 months from the date of handing over possession of the building, and the builder is not handing over the possession, and therefore the authority can pass appropriate orders under section 31. The last but not the least is the developer's right. What happens when the flat purchaser does not give the amounts as per installment? Now people have faced this situation where RERA has passed an order. So initially we used to move RERA under section 11(5) and say that cancel or terminate the agreement executed in favor of one of the flat purchasers. But the question came is, there is a registered agreement already registered with the Office of Sub-Registrar. How do you replace that, or how do you get it cancelled? So who will execute that cancellation? If the flat purchaser is not coming forward, there was no mechanism. Recently RERA came up with a circular that in such circumstances RERA will provide their representative for execution of deed of cancellation, which will solve this issue. So we have seen the litigation from the starting point of the society, then flat purchaser, and to end with the builder. As I said, the last is that builder secures his last penny to be recovered under the agreement for sale, which there is a remedy provided. Now, we are aware that the property agents are required to be registered under RERA. Now, what happens if he is not registered? So, in fact, the first case of RERA started with a fine to a property agent. Yeah, so the RERA can initiate action and award penalty if the property agents are not registered with RERA. And even promoters are required to upload on their website the details of the property agents who have been authorized to represent particular promoter. An interesting case which in last 3 minutes I will explain. We have so many websites who are marketing these properties. So a case was filed by one of the developer association that on one hand you are mandating individual person and company to register with RERA, and on other hand these websites who are marketing projects without even knowledge and consent of the promoter. What are you doing to them? And RERA passed an order, of course it is in challenge, under challenge, but RERA passed an order mandating that even the website sale is a sale or amounts to marketing of a project under RERA and requires registration with the authority. I think I have completed the part of litigation regarding redevelopment and the process of development. So if you have any questions, you can ask me the questions.
We can take 3 questions quickly. If you can raise your hand. Yeah, over there.
I'll just take some water. Huh? Thank you.
Good afternoon, sir.
Hi.
In 337 redevelopment, which is also registered under RERA, but the rehab portion does not get any protection from RERA. In that case, what is the remedy for somebody who's getting a rehab apartment there?
I didn't get you. See, the rehab component never gets protection under RERA because a member of the society, existing society which has gone for redevelopment.
No, sir, it is 337, not
Correct.
society. Yeah.
Yeah, but even 33(7), any kind of redevelopment does not get protection of RERA. RERA is only meant for flat purchasers and not for existing society owners or building owners who give it to the promoters. In fact, they become co-promoters.
Even the tenant?
Not the tenant.
Yeah, exactly, sir. Society members
So even,
become
even
co-promoters.
tenants cannot go to RERA. That's what I answered.
So
See,
what is their remedy? Which statute they will refer to when they...
If he has a dispute with the developer, then he will have to go to the court or arbitration, whatever is provided under the development agreement or PAAA.
Okay. Thank you, sir.
Hi, I have a question. In case of a society undergoing a redevelopment, and if the existing members, they, approach the builder that, look, we also want to have extra area. And in case if they decided, the builder decides to sell extra area to the existing society member.
I know your question. I'll answer it right
Then
away.
will this be covered under RERA?
100%.
In case if the builder defaults and he approaches the RERA,
See,
will
there
the
are-
RERA entertain them?
There are two ways of looking at your question, and I'll answer both. First, from an angle of flat purchaser, the immediate answer is yes. The minute you purchase additional area, you become an allottee within the definition of RERA, and you can raise your grievance with the authority. Now, the second question which you did not ask, but I will tell you what happens. The promoters insist that when a society member purchases additional area, he should make that payment forthwith, because thereafter they cannot make changes in the apartment if that additional area is sold to the flat purchaser. So the second question is it legal, because the project is not yet registered and the promoter is insisting for sale of additional FSI directly. The answer to that is normally whenever such type of arrangements is made, it is made in 2 parts. First, as you rightly noted, in a development agreement, and that sale or allotment of additional area is always a subsequent where the sale deed is executed and not PAAA.
Thank you. We will take last 2 questions.
Yeah, hi. There's a situation where around 40-50 years ago, when the old developer sold the flats, he sold proportionate land ownership also to the flat members.
See, that comes
So,
and
yeah, so what happened subsequently, a society was formed. Now it's going for redevelopment. Now 2 or 3, 4 of them have got their brains together and gone to the court and saying now this land belongs to us, so much portion. So we want more FSI, we have the right to more. So do they have a standing against the society in that?
see, I'll explain. When initially MOFA came in 1963, before that, in fact, MOFA came because of this situation. Maharashtra Ownership of Flats Act came because of this situation, because there was no recognition to a separate structure prior to MOFA. Now what happens is when 4 flat purchasers or 3 flat purchasers in those days, G+2 structures typically, purchase those apartments under Maharashtra Apartment Ownership Act, they would get ownership directly in the land, and then they are right in claiming benefits as a owner of the land. They have a right. Of course, yes. It is not a society now, it is a, see, there is a
The
difference.
rest of the members have formed a society. You understand that?
No, no, I understand. I am just trying to explain it again. Yes, because I'll tell you why. The next, maybe 20 people got separately registered themselves society is not a society under Maharashtra Ownership of Flats Act, where deemed conveyance is to be executed in, I explained, I'll just quickly answer you again. I explained what is deemed conveyance under section 11. It is when a developer completes the building under MOFA and then he is bound to execute deemed conveyance in the name of the society. But here is your case where developer had constructed it under Maharashtra Apartment Ownership Act. So there it is just a declaration under Maharashtra Apartment Ownership Act. It is a declaration under section 2. Now that declaration makes them, those 4 flat purchasers or 5 flat purchasers, owners in the land. And the society is not the owner of the land. So that is why those owners in the lands are justified in claiming themselves as
A
owners.
similar situation where the landlord has given part of his land and a society is formed. 40 years back, a society is formed. And now the landlord is creating hurdles in the redevelopment of the society. Can you?
No, I'll answer that. Yours is not a similar situation for the simple reason the existing landlord has given development rights. So he himself has sold the additional FSI available on the land.
Society
Therefore,
is formed, conveyance is also done.
correct. So now he is no more a landlord.
Okay, great.
So one more question. Legally, is there a ceiling limit or how long these disputes can go on once a
How long?
society is going into redevelopment? Say most of the societies are going in redevelopment with grade A players, Oberoi, Lodha, Kireja. Now, if there are any disputes in the future, what is the overarching body which will govern this? Because,
Between whom? The society and the builder?
yeah,
I told you.
if there are any disputes,
Civil suits or arbitration clause. All these names which you take, they have arbitration clause.
sir, there was a case in Bandra where there was a private equity firm which was handling a redevelopment case, and now that fund has exited India. So what happens in these kind of cases?
So, similar situation has happened in Thana also, where foreign funds was involved and then they abandoned the project. I explained to you that there is a remedy under section 7 and section 8 where you can go to the authority and ask for takeover of the project if your association of allottees. If your society takes steps for termination.
But quite a long time to handle all this.
Time has never been essence in India.
Thanks. Just-
Just takes one last question from you.
Sir, we had a building at CP Tank. The building was completed in 2005. Builder has some manipulated tenancies. So there is a dispute between MADA. As MADA is not issuing NOC. And that is why we
MADA
have
has?
MADA is not issuing as a NOC because builder has manipulated some tenants.
Okay.
So OC is not, BMC is not granting the OC.
Okay.
So this is the reason. So what to do for that? And we have gone for deemed conveyance. So they are arguing that their building is under litigation, some disputes are there.
Sir,
And-
deemed conveyance has got nothing to do with dispute of tenancy with MADA, point
Yeah,
number one.
right.
But something which may be against you is your building doesn't have occupation certificate.
Building has?
You said you don't have an occupation certificate.
Yes, we don't have, because occupation certificate is not received. We have applied to BMC. BMC said get the NOC from the MADA. And MADA is saying that because the builder has a manipulated tenancy. In fact, it was a 28.
Right person is Milind Jangani sitting here.
Okay.
Because I'll tell you, it's not.
I thought litigation.
I will tell you. Litigation, I have answered that you can file a suit against the erstwhile builder,
Okay.
or even you can go for deemed conveyance. But how to get NOC from MADA, or what is the requirement, that possibly he would be able to answer. Can you just hand over mic to him? There's NOC of MADA over disputed tenancy.
So this is a problem for almost for 2,000, 3,000 projects where builder को surplus देना था माड़ा को नहीं दिया.
दिया नहीं.
बिल्डर ने टेनेंसी इन्फ्लेट कर दी, 10 थी 15 कर दी, और ये सारे रीजंस की वजह से which have now got highlighted. NOC to OC is not coming and therefore OC is not coming. Your only recourse today is to go to court. Okay, and you have already delayed if you have not gone.
If 2005 building,
Because it's been 2005 to 2025 in your case, but there are certain cases much before also, and 20 years have passed and you are being in a building with unauthorized occupation is itself is a problematic. Government of Maharashtra is working out a policy to give occupation to buildings. बीच में आया था newspaper में, but again procedurally it has been kept aside, so nothing is happening there. In your case, like many other buildings, tenants have gone to court, displayed their willingness to comply with the fire regulation. Hopefully the building is constructed as per the approved plan. The court will give a reasonable interim order that kindly grant NOC and you conduct separate FIR on the developer for recovery of your dues or for other purposes. But as far as whatever is permissible, कम से कम उतने को OC आ जावे. But you need to go to the court. I think that's your only remedial measure right now available. It will also take 2-3 years.
Thank you, sir. I hope that answers the question. Many more questions, if any, we will take it in the networking zone. If you could please share your contact number for everybody over here.
it's 98203 00135.
बहुत बहुत शुक्रिया, sir. Thank you so much. I'll
Thank you
request you
very
to
much.